What is procurement law? Procurement law is essentially contract law, but with some specific procurement legislation involved. Procurement law is all about buying or selling goods and/or services. In this video, we'll be focusing on public sector organisations. Procurement law can span across many different industries or sectors. This can include purchasing goods, for example, on behalf of the NHS, a local council, or even a police force. So you might be thinking, why procurement law and why is it important? So across the public sector, there are multi-billion pound contracts at stake. It allows for the safeguarding of public funds. It avoids corruption and bribery throughout the ecosystem and promotes transparency and fairness, not only within the public sector, but the contractors that they work with. Legislation. The main legislation involved in public sector procurement is firstly the Procurement Act 2023, which went live in February 2025. Prior to this, it was the Public Contract Regulations 2015, also known as the PCR. So if you had contracts prior to February 2025, that would be the legislation that was under. Alongside this, you have a whole host of different government guidance, particularly for the new legislation. So what is a procurement? A procurement is a formal exercise to obtain a supplier or bidder for a relevant need. Relevant bidders or suppliers will tender under that formal exercise. In that process, you may receive several bids from different suppliers. Depending on the complexity or the value, there may be different stages to the procurement. And at the end, there may be a valuation stage. Throughout a procurement process, there may be many different elements for legal to support with. So firstly, KPIs, key performance indicators. These can either be set at the beginning of a whole new procurement or reviewed against conduct of an existing supplier. Questionnaires, so setting questions at the beginning of a procurement exercise to ensure that they're fair, transparent for all. ITTs, these are invitations to tender, and these are essentially documents which set out all the relevant information at the beginning of a procurement exercise. Exclusions. Under the new Procurement Act, there are a number of grounds where people can exclude certain suppliers under specific scenarios. Responses, so reviewing and responding to questions posed by potential suppliers and bidders. And last but not least, preparing contracts and negotiating contracts. Challenges. So organisations can bring challenges against organisations throughout the whole procurement process. Now, these can be informal challenges or they could be formal ones through the court. So from a legal perspective, we must ensure that we are following the relevant legislation. So whether that's the PCR 2015 or the new Procurement Act, ensure that the client is having accurate record keeping throughout the process, ensuring that we're treating all bidders and suppliers fair and transparent, and of course meeting all relevant deadlines. Watch this space for more exciting content.